Good afternoon, and thank you so much for joining us today. We are thrilled. So many of you have joined us for our seventh board training webinar of the year. This one is on advanced collections for HOAs and condominium associations. If we have not met, I'm Julie Howard, co-founder and managing partner of the firm. As always, at the start of the program, we want to thank you for the continued opportunity to work with you and your board of directors. This year, it is truly our privilege and pleasure to support such an incredible group of volunteer leaders, and we are grateful that you have entrusted us to advise you and help you lead your communities. I'm here today with our partner, Vicki Sand, and Senior Associate Craig Cooper. Vicki and Craig lead our collections team and our incredible collections paralegals. Vicki and Craig will be leading today's program, and they're going to dive deep into collections, bankruptcies, and foreclosure. Also, we are happy to share that Jocelyn Gusta has joined us as our client services and marketing coordinator. Jocelyn is a great resource for you for our classes, articles, and blogs. And her email is Jocelyn, Jocelyn, at noahcoward.com. Please know that you're welcome. We welcome your comments and feedback anytime regarding our classes or anything else. And you can send that to Jocelyn or academy@noahcoward.com. Regarding today's class, Jocelyn is going to send a follow-up email by the end of the week with today's course materials. Finally, please note that before we get started, we can only share general information through this webinar format. If you have specific questions or need legal advice for your community, or a question about your association's governing documents, please reach out anytime to your general servicing or collection attorney for specific legal advice, and we are more than happy to help. That said, we will, as always, take your general questions throughout today's program. Feel free to ask your questions in the Q&A feature of this Zoom webinar, and we'll do our best to get to as many of them as possible. But again, please feel free to reach out to the team if you have specific needs. With that said, we're glad you're here. Vicki and Craig have a great new kind of format lined up for today. And Vicki, take it away.
Thanks, Julie. And again, thank you everyone for joining us on our advanced collections class today, where Craig and I will be discussing association foreclosures, bankruptcy, and collecting fines. So before we dive in, we have our first poll question. And while Jocelyn gets it on screen, our first question is, when was the last time your association had an association foreclosure? And your choices are going to be never, 5 years ago, or no clue. And I'll give you guys a minute to answer. Hey, Jocelyn, does it look like most people have had a chance to answer?
Just about almost. I think so, yeah.
Great. Can we show results? Great. So it looks like the majority of you have never had a foreclosure, and that is great news because it is a last resort option, and we're glad you haven't had to go there. About a fifth of you have said 5 years ago, and about a fifth of you have said no clue. So you are in the right place because we're going to tell you all about foreclosures. So next slide, please. So now let's dive into an association foreclosure.
So, Vicki, what is an association foreclosure, and how is it different than a mortgage lender foreclosing?
That's a great question. So an association foreclosure is a very aggressive collections remedy available to some associations if they can't get their accounts paid in any other way. So this is an option that is available to condominium associations and associations that are subject to the Georgia Property Owners Association Act. So normally in Georgia, anyone can foreclose on a judgment so long as that judgment is in first priority lien position against a piece of property. However, Georgia law has carved out an exception if you're a condominium or you're subject to the POAA, allowing you to foreclose subject to any prior liens.
So why is this carve out significant?
So this is a big deal because it drastically brings down the cost of foreclosure for the association. Instead of incurring hundreds of thousands of dollars to pay off the first mortgage against a property, the associations can now foreclose for some costs around the $4,500 to $5,000 mark or so, so significantly less.
So before we get into it too much, first let's talk about what's required for a foreclosure sale to take place.
That's a great idea. Next slide, please. So here we have the current statutory requirements for an association foreclosure. And I want to emphasize the word current here because, as you know, requirements for POAs are going to change on January 1st, 2027 under the new legislation. But right now, the current requirements are a lien greater than $2,000, 30 days notice that the association intends to foreclose. Then we have to obtain a judgment in excess of $2,000 and an order of judicial foreclosure on the association's statutory lien from the court. And once we have all that, can we work with the county sheriff's office to schedule the actual foreclosure sale?
So this sounds like a lot. I take it this isn't a quick process. Is that right?
No, it definitely is not. On average, I would say it takes about 18 to 24 months to get from demand letter to foreclosure sale. You have to keep in mind that it takes 6 to 9 months alone just to file suit and get the judgment. And that is assuming that everything moves along and there are no hiccups.
Right, because there's never any delays in the court system.
Exactly. Next slide, please.
So, guys, if you back up for 1 second, I had a question slide about what applies to condominium associations versus property owners associations versus HOAs with this. So can you distinguish that?
Yeah. So right now, everything you see up here applies to both a condominium and a POA. This is not a process open to common law homeowners associations because they don't have the carve out that was created for condominiums and POAs. So everything you see here is a requirement for a condominium or a POA right now. A few slides from now, we will get into some of the upcoming changes that will be effective January 1st as they relate to foreclosures and collections in general.
Thank you.
Great. So next slide, please, Jocelyn. And so here we have the entire process for after we obtain the judgment and order of foreclosure from the court. We have to apply for and get the court to issue the judgment lien, also known as a FIFE. We got to get our title company to order a title search for the property. And then we have to prepare a whole foreclosure package for the sheriff's office and in order for them to move forward with sale. Because while the sheriff's office conducts the sale, they look to us to prepare kind of all of their paperwork. So that includes the advertisements, the deed, if it does go to sale, and a bunch of other stuff in between. Now, once the sheriff's office receives it, they typically submit it to the county attorney for review, which honestly can take however much time they feel is appropriate, usually a few weeks. So once the county attorney has blessed our foreclosure package and approved us for sale, the sheriff then has to levy on the property, advertise for the sale once a week for 4 weeks leading up to the sale, and then conduct the actual sale. Foreclosure sales in Georgia must take place on the first Tuesday of each month on the courthouse steps between the hours of 10 a.m. and 4 p.m.
So, Vicki, this is one of the more fun parts of our job. Can't be the most exciting.
Yeah.
So, what actually happens at the courthouse steps at these foreclosure sales?
So officially, we are going to send an attorney from our office to attend the sale and bid on behalf of the association up to the judgment balance. hopefully with a credit bid that's been authorized by the court. As a matter of personal preference, I really like to open bidding with the judgment balance to as the first bid given in the auction.
And
I have a
why?
question. Oh, sorry.
Yeah.
Before you, so on the amount of the
Mhm.
sale,
Yes.
can the association update the foreclosure amount if the owner has not been paying their post-judgment assessments?
That is a great question. And unfortunately, no, because what you're technically foreclosing on is the judgment. So we cannot reopen the judgment to add more fees that occurred after the judgment occurred. So,
Okay.
so we're,
Yeah, go ahead.
oh, I was going to say, so we are restricted to the judgment balance. The only exception is judgments in Georgia accrue interest by law. So depending on how long it's been since we got the judgment, there may be a significant amount of post-judgment interest that has accumulated that we can include in our bid.
Great. All right. I'll pop off, but just for the audience sake, both of these great questions have come from your fellow attendees. So if you put your questions in, I'll pop in and get the expert opinion. So thanks for the questions so far.
Thanks, Julie. So Craig, I think you were asking me why it's important to open bidding. And actually, open bidding is not important, but I am a pretty impatient person. So I like to hurry these things along. Otherwise, we would have to sit there while they go up in increments of $100 and got to, our judgment balances. But we want, in reality, just not just because I'm impatient, we want the winning bidder to outbid the association because that means that the judgment is going to be paid in full. And typically, I don't think any association wants someone buying into their neighborhood that didn't at least pay the full amount of the judgment balance.
And that's the whole reason we're here is to collect on that balance. So this makes sense to me.
Exactly. So after that, if as long as there's a second bid, I will typically withdraw from bidding, but I like to stick around, see how it goes. Auctions are anything can happen. And Craig, we've seen a lot. So, and then I try to identify who won the auction and introduce myself afterwards. So they initially have a lot of title issues to deal with, but eventually they'll be ready to deal with the association. And I want them to already have my name as someone they can reach out to when they're ready to deal with the association as the new owner.
All right. I have questions. So before y'all go on, they are coming in fast.
Good.
All right. So these are all foreclosure related. What if the association files suit before the end of the year, maybe later this month, and it takes 18, 24 months after the new act is in place? What will govern the foreclosure amounts?
So if we're talking about the new law SB 406,
Yes.
they are kind of drawing a distinction between lawsuits that were filed before July 1st for the new notice requirements that were imposed on POAs. And they're basically drawing the line based on the lawsuit. So if we were to file suit today, you would not be then required to satisfy the requirements that are going to come into effect January 1st, 2027. So which we will get into in just a little bit. So it's going to determine based on when the lawsuit was filed, which means for Craig and I, we're going to be looking to try to get as many lawsuits filed before the end of the year and take them out of the new requirements as possible.
Okay. All right. Question we have is it faster to file in small claims or magistrate court? So, can you talk about the fact
Yeah.
that
So,
foreclosure has to be filed in Superior Court?
yeah, we actually we cannot file a foreclosure action in magistrate court because while that court does move faster, they have some limitations. The big one is a jurisdictional limit of $15,000. They cannot award a judgment that goes higher than that, even if it's costs or attorney's fees that push it over the amount. And the other big reason is in foreclosure is considered an equitable remedy under Georgia law, and only the superior courts have the power to grant a foreclosure order. So the small claims or magistrate court and even the state court don't have those powers, so we have to file in superior court.
Okay. And regarding the question I asked a minute ago about the fact that the association can't include post-judgment assessments that have come due after the date of the judgment. The question is, if you foreclose, will the owner still be responsible? Or will the new owner, if someone takes it at foreclosure, be responsible for the post-judgment assessments?
So that's a little complicated. The former owner remains personally liable for any assessments that came due from the date of our judgment to the date of the foreclosure sale. However, we generally do not recommend collecting against them because the foreclosure sale just deprived them of their home. So if they were collectible, they would have taken action to prevent our sale. So that is reviewed kind of on a case-by-case basis. The new owner will be personally liable from the date of for assessments that come due from the date of the foreclosure sale forward. So they don't owe the post judgment that came due before the sale, but they will owe like any other owner from the date of the sale forward.
Okay. Question either of you, if the home is, if the association is pursuing foreclosure of a home or unit that has multiple other liens filed in excess of the home's value, why would the association want title? So can you talk about why the association would pursue foreclosure?
Yeah, so we actually cover that in a little bit, but for
Okay.
now, what I will say is that number one, you don't have to be worried about the other prior liens, even if they add up to more than what you believe the property is worth. We will foreclose with those liens intact, so they don't need to be paid off before sale. And then after sale, it really depends on what you, the association, would want to do with the property. If you end up with title, you could potentially resell the property for, if it's worth it, for more than all of those liens and pocket the equity. On the other hand, there's also the factor that the person who lives there now is not paying you. If we're at the point of the foreclosure sale, we've sued them, we've gotten a judgment against them, and we haven't been able to collect in any other way. They are dead weight. And so the foreclosure sale at least forces a title change, gets them out, and potentially a new person in who is going to honor their commitments for being an owner in the neighborhood.
All right. And then last two questions. One, is there a different process for a common law HOA as opposed to a condominium or one subject to the POAA? And then what happens if the association is foreclosing on a home and then the bank starts foreclosure? So if you want to work those in, and then we'll take all the next questions at the next break, and
Great.
I'll let you get back to it.
So if you're a common law HOA, you do have a separate process called a levy and sale process that is very similar to foreclosure, but it just doesn't come with the court order of foreclosure. And we will have to basically prove to the sheriff that we are in first lien position, which usually means you're going to have to pay off the mortgage, and then convince the sheriff's office to move forward. And we've only done a couple of these in my time here, but in my experience, the sheriff's office is going to require that your judgment bear some relation to the value of the home. They usually are looking for at least 1/3 or at least 1/5 is the lowest percentage I've heard, which is a bit of a problem. And because most homes have a mortgage on them, we just don't recommend it for common law homeowners associations. And then the question about mortgage lenders. So what happens is the mortgage lender's lien has a higher priority than the association. So it's going to matter who is able to take action first. If we foreclose first, our foreclosure goes through, but when the mortgage lender forecloses, they're going to take the property away from us because their lien has a higher priority than we do. As a practical matter, if we find out that the mortgage lender is foreclosing while we're somewhere in the middle of this process, we'll probably reach out to you guys and ask if you want to hold off because they are going to take precedence. So whoever buys at our sale is going to immediately lose it, usually the next month or so to the mortgage lender foreclosure, because they can get to the sale much more quickly than we do. Jocelyn, can we go to the next slide? So kind of getting back on track, I know we've covered a lot of this already. Great questions, everyone. But I want to talk about the three ways a foreclosure sale can end and who can end up with the property. So it can end one of three ways. The most ideal is a third party. The second way is the association. And then the third way is no one, because no one bid, and in which case the sale fails. And so we never want to do that. We would have to start over, which is why we always send an attorney to bid at the sale. So I would hate to start over after all of that work. So like I said, if a third party purchased the property, it is usually some kind of investor, and this is generally the ideal outcome for the association.
So, Becky, why is that the ideal outcome to have a third-party investor purchase the property?
So simply because you are receiving somebody else's money to pay off the judgment that is owed to you as the association. Otherwise, in the second scenario, the association is going to end up with the property. And as I mentioned earlier, there are a number of options for the association, but none of them are as good as just receiving a check from someone else. If the association ends up with the property, they can evict whomever is living there, whether they're the former owner or a tenant of the former owner. They can try to resell the property for more than the mortgage, essentially flipping it and paying themselves out of any equity resulting from the sale. Or they can talk to the mortgage lender, try to negotiate short sale if that's necessary. Or, as I mentioned to the last question, they can just wait for the mortgage lender to foreclose. That sale can potentially result in excess funds, which the association has a very good claim to usually. So that could be another route. But like I said, none of these are as good as receiving a check from somebody else. We believe that the mortgage lender will be pretty quick to foreclose after our sale because at that point, the owner doesn't own their property anymore. And if it were me, I would not continue to make mortgage payments on a home that I didn't own.
Yeah, I certainly wouldn't either. But let me ask you this just generally. So this all seems like a lot of this entire process. So why, aside from what we touched on, what are the reasons associations would go forward with this whole process?
That's a great question. And Jocelyn, if we go to the next slide, as I mentioned at the beginning of this section, this is really the last resort option. It shouldn't be our go-to option, and we should really be only doing it where we cannot collect any other way. We've gotten a judgment. We've talked to the owner. We've tried to explain to them why they need to pay these amounts. We've garnished. We haven't been able to find things. That's when we should be looking at foreclosure, is when all of those other ways have not worked. And assuming there is no other way, there are a lot of benefits to making it all the way through this very long and complicated process.
So could you touch on those benefits just for a little bit?
Yeah, so the big ones are up here on the screen. Ultimately, it's stopping the bleeding. Right now, if we have sued an owner and we got a judgment against them and we're looking at foreclosure, they're not paying the association, meaning they're not paying their fair share. And so foreclosure is a very, very final way to get the bad neighbor out and hopefully get a better neighbor in who is going to do their fair share. But even if we never get to the foreclosure sale, the initial notice where we have to notify the owner that that's where we're headed can often be enough to prompt the owner to take this a lot more seriously than they have been. A lot of people kind of stick their hands in the sand, but once they get the letter and they see the word foreclosure, they start thinking, okay, maybe I should sell my property. Maybe I should look into bankruptcy. Maybe I should, explore some of these options other than just sitting here and saying, hey, I can't afford it. So next slide, please.
Yeah, so if and this has been touched on already with one of the questions that was asked, but let's talk about the elephant in the room. There's been obviously, I think everyone is aware of the new laws have been passed, SB 406 or Act 715, whatever you like to call it. Um, uh, how is this affecting associations as far as collections are concerned?
Okay, so I'm glad you asked, and we're going to cover this in two parts, changes specific to the POA foreclosure process, and then changes that are going to apply to all associations for collection cases. So for associations that are subject to the Property Owners Association Act, effective January 1st, 2027, the foreclosure threshold is going to double to $4,000 from its current level at $2,000. They also included a super complicated formula related to 1 year's worth of monthly assessments, so long as they are equal to more than $2,000.
So for the purposes of this class, let's disregard that exception and stick to the four
Yeah,
thousand
let's
dollar mark.
let's stick with the 4,000. Good idea. We will also need to start giving 60 days notice of the association's intent to foreclose in our demand letter, and we can only use the newly defined terms of regular assessments, special assessments, and specific assessments to reach the foreclosure threshold. Specifically, it means that attorneys' fees, management companies, and other maintenance costs cannot be included in this calculation. So I do see an error on our slide that will get fixed, which we've recently revisited SB 406, and we think that interest and late fees may be able to be included, but there will be more guidance from our firm on that moving forward. But the point is, we can't include attorney's fees, management company fees, maintenance costs, and some other scattered fees to get to the $4,000 threshold.
So this is a big change in terms of reaching that threshold. Is that right?
Yeah, this is big. I think it's going to be taking up a lot of our time and attention come January. Next slide, please.
Yeah. So if that weren't enough,
Yeah, on top of all of that, there are even more changes that apply to all associations, including new definitions for regular assessments, special assessments, specific assessments, fees, and fines.
and or lack of definition rather, as you see, we're continuing to analyze these definitions as they've been passed by Congress or by the Georgia legislature rather.
Yeah, one glaring mistake that we've already kind of zeroed in on is they use the word fees and fines all over this legislation, and they don't really define them.
So what else? What other kind of changes can we see here?
Okay, so I think the other big change is they're no longer going to allow associations to accelerate their assessments to the end of the fiscal year. So if you've been a client for us for a while and you charge monthly or quarterly or even semi-annual assessments, we will no longer be able to accelerate the assessments when we go to file suit. There is also a new payment application mandated where we will need to pay the newly defined regular assessments until paid in full, special assessments until paid in full, and then specific assessments until paid in full. And then basically there is a catch-all category of everything else.
So what is this everything else category entails? This late fees and interest on the unpaid assessments, and did those have priority over fines?
Craig, I wish I knew. The law is silent to this, and we don't have a lot of guidance, so we're going to have to wait and find out. And then the final part of the new law that really affects collections is we can no longer refuse partial payments of any kind.
So what does that mean when an owner makes a payment and writes on the memo line, this is my in full satisfaction of this debt, also known as a restrictive endorsement? What does that mean going forward?
Again, I wish I knew. But I can tell you how we're probably going to handle it, which is until someone tells me otherwise, I'm certainly going to argue to judges that the restrictive endorsements have no effect because the association can no longer refuse to cash that payment.
So in some of these situations, we're going to need to wait until the Court of Appeals makes a ruling.
Yep. Super fun time to be an attorney, isn't it?
Absolutely.
So finally, I want to emphasize that the changes that we're discussing right now are only the collections related changes in the new law. There is a lot of ink spent discussing a new registration requirements with the Georgia Secretary of State's office, the complaints process, and the homeowner bill of rights. They just are not in the scope of this class. And so I would hate for our board members to think that this is all the new law does. I'm sure we will be releasing a lot more guidance in the coming months about the new requirements. So please stay tuned on that.
A checklist coming out soon. We're kind of, keeping it top of mind by, I did the training in June and back in April, and now we've got a blog up, so you can visit that at noahcoward.com. It's the most recent blog entry with all of these detailed, and now we'll also be sending out a checklist for you to keep it handy. So before you move on, I have two remaining questions. One is, can you talk about lien priority and the difference in lien priority for condominiums and associations subject to the Property Owners Association Act versus common law HOAs? Specifically, there was a question about where mechanic or materialman's lien fell in the order of hierarchy. So can you talk about race to the courthouse, statutory lien priority, those fun things?
So liens are a hot mess under Georgia law as a basic response, and they're really complicated. And so it's a lot of things are going to be very fact specific, but kind of big picture items are the loan you take out to buy your home is always going to have first priority lien position against your home. That is just how secured transactions work in the US. If you are a condominium or subject to the Property Owners Association Act, then the association's lien usually comes right behind the mortgage. There are a couple of exceptions, like a second purchase money mortgage, and things like that. But if you're a condo or POA, you usually have first bite at any excess funds resulting from a mortgage foreclosure. If you are a common law homeowners association, we get into what attorneys like to term a race to the courthouse. You have the right to lien the property, but your lien is not perfected, or another way to put it is nobody knows about your lien until you get a paper lien recorded in the county lien records. And it is going to come down to when the county clerk accepts that for recording, and they're all kind of kept in chronological order by the clerk of court. So the HOA, Common Law Homeowners Association's liens, their priority is going to depend on what else is filed against the property at the time the lien is recorded, is going to matter about their priority. Other types of liens they don't have priority over the association, but they can jump in front of the association in certain situations. One I think everyone is familiar with is property taxes. So if you don't pay your property taxes to your county, they can put a tax lien on your property, and that lien can jump in priority in front of your mortgage in certain circumstances for a tax sale.
Think of that as the government always wins.
Yeah, the government definitely always wins. And then a material mechanicsman lien, these are really special. They do have a decently high priority, but for a very limited amount of time, because they are there for if a subcontractor who did work on your home does not get paid. So they have to file that within a certain amount of time of the job being done. And then if they want to pursue that claim, they have to file suit within a year of recording that materialman's and mechanics lien. Otherwise, it just kind of goes away as a matter of law. So if you have this situation, reach out to us so we can take a look at the big picture, because it's going to depend what else is on the property.
Yeah. And then speaking of the statute of limitations for a mechanic materialman's lien. One other question before we move on. This board member is the way the question is written, understood that an HOA can only assess 4 years of assessments. I think there's some confusion on the 4-year statute of limitations.
Got it.
So can
Okay.
you talk about the statute of limitations?
Yes, that is a great question, because it's confusing because they are the same time period. So there are two different time periods that you need to be aware of that are both 4 years. So one is your lien is good for 4 years. So on the day I file it, it remains of record, then it will expire as a matter of law 4 years from today. Okay. Then at the same time, there is something known as the statute of limitations, which is sort of a deadline that Georgia law sets on how soon after something happens that you have to file suit to basically pursue your claim further. Like a lien doesn't go very far. And so the lien has no effect on the statute of limitations. The statute of limitations basically says that on the day I file suit, I can only include amounts that go back 4 years. So if I filed suit for you today on July 22nd, 2026, I could only include amounts that came due after July 22nd, 2022. So it's confusing because they're the same time period, but they don't have a lot of relationship to each other. The lien does nothing to stop the running of the statute of limitations. You have to file suit. So that was a lot on foreclosure. We are going to switch gears. Next slide, please. And we are going to shift our attention over to bankruptcy. And as Craig is our in-house bankruptcy expert, he and I are going to shift roles and he's going to tell us about bankruptcy. But before that, we have our next poll question related to bankruptcy, which is what percentage of Chapter 13 cases are dismissed before successfully completing the case and receiving a discharge in the metro Atlanta area? Your options are 30%, 50%, 65%, or over 70%. We'll give a minute for everyone to answer. Cool. So can we show results?
Yeah, so this was it's going to be a fun question, but also to outline a couple different issues. So in the Northern District of Georgia, which is the Metro Atlanta area essentially, and some areas north of that, over 70% of Chapter 13 cases are dismissed prior to completing successfully. And I think that kind of sets the tone and gives us some context about how difficult it is for debtors. And I'm going to use the term debtor and owner interchangeably here, but that the debtor's meant to mean someone that's filed a Chapter 13, 7, or 11 case. How difficult the process is for that individual and how often it is unsuccessful.
Wow. So Craig, let me start with a basic question. What is bankruptcy and why do our clients need to know about it?
Great. So that's a great question. So bankruptcy it's a federal process that helps people who can no longer afford to pay their debts seek relief by either liquidating their assets or forming a repayment plan to pay back their debts with the protection of the automatic stay. It's important to note that bankruptcies are going to be governed by federal law. Georgia law only applies in certain limited circumstances and in a very limited context. So what we're talking about here are federal lawsuits filed in a federal court. It's also important to understand the purpose of the bankruptcy and how it's looked at by the judges and all the parties involved. Essentially, the purpose is to give the debtors, the individuals, a fresh start so that they can address their debts and move forward. The purpose of the case is not to benefit creditors necessarily, although it is a secondary purpose to benefit the bankruptcy estate, which may include some of the creditors. So it's important for our purposes to know a little bit about bankruptcy, just because each homeowner has the right to file a bankruptcy at any time with some very limited circumstances. And it's important to know how these cases work and what to do when one comes up in your community.
So next slide, please. And all right, so let's say a bankruptcy has been filed in one of our clients' communities. What do they need to know?
So the most important concept by a long shot to understand is the automatic stay.
And why is that so important?
So as soon as a debtor files a bankruptcy, the automatic stay goes into effect, and this acts as a automatic injunction that stops collection efforts of all creditors. So this happens immediately once the case is filed and goes into effect immediately. So, um, that, and I want to repeat that point there. As soon as a case is filed, the stay goes into effect and takes effect immediately. And this can even come down to the second of the case filing. In certain cases, we check the timestamp of the petition filed with the bankruptcy court in order to determine whether the case was filed in a foreclosure context, whether the bankruptcy was filed before the sale is cried, and at what time exactly it was filed. It could come down to the minute or even second in some situations. This has happened recently. We had a foreclosure sale several months ago where we always check, determine whether there's been a bankruptcy filed prior to the sale that morning of, and we'll attend the sale. The sale will be cried. No one knows that the bankruptcy has been filed, but when we come back and look at it, if we check again and there has been a case filed, that as long as that case was filed right before the sale, it has to be undone, which kind of puts us back into square one as far as the foreclosure is concerned. But this basically just highlights examples of the effect of the timing of when the bankruptcy case is filed, and that it goes into effect immediately, even if the creditors or the association doesn't know about it.
So why do they do this? Why do they impose an automatic stay immediately upon the filing of a bankruptcy petition?
Right. So the automatic stay is meant to give the debtors a breath of fresh air, so that they could propose this repayment plan or liquidate their assets to pay their creditors. It's to stop really any collection efforts, whether that's foreclosure, garnishments, lawsuits, phone calls, even lien filing.
Wow.
And it's bankruptcy judges protect the automatic stay severely. So there's consequences for violating the automatic stay. The best example of this that we ran into, and this was a little while ago, about 10 years ago or so, was a bankruptcy court essentially awarded a debtor a $15,000 judgment against an association. And this is for a stay violation. This is a rather egregious example.
Wow.
And we also want to keep in mind that this is something that would put the association on the front of the newspaper, in some
On
of
the
these.
nightly news,
Yeah,
probably.
yeah. So that we don't want this type of publication, obviously, and this is a good way to use the bankruptcy system to for the association to get attention, and not all publicity is good publicity.
Yeah, we don't want that kind of attention. Next slide, please. So now we know how important the automatic stay is. Let's move into a more practical question. What should the association do once they find out about a bankruptcy? Call us.
Yeah, that's right, 100% right. Stop everything and call us. Even if you weren't handed documents, call us. We'll take a look at it, and then immediately stop all collections activity. This we talked about, some of it means that you can't go forward with a lawsuit, foreclosure action, but it also means that the owner should not be contacted about a past due delinquency. And most importantly, and I think that that's kind of a sticking point where we see our clients have some questions about, is all amenities that were previously restricted because the delinquency must be reinstated. So
Wait, wait. So owners in bankruptcies, they probably haven't paid in years and they still get access to the pool again because they filed bankruptcy.
that's right. And it sounds unfair, and it may be, but that's one of the realities we had to face with the bankruptcy. Any type of amenities that would be available to the individual, aside from the fact that they are delinquent, must also be available to them after a bankruptcy case is filed.
Wow.
So, and another important note about the automatic stay is that an individual does not have to produce documentation showing that they filed a case. And in case law, it's been established that as long as a creditor and association has been put on notice that a bankruptcy may have been filed or has been filed, then the courts are going to impute notice of the case and then thus the automatic stay. So um, we've had situations where our clients have said, well, they never produced anything showing that they're in a bankruptcy. Again, stop what you're doing and call us, and we'll make that determination. They don't have to produce anything. The other important, I'm sorry.
I have a question about the stay. What happens if the board is denying access because and they didn't know that the bankruptcy had been filed?
Right. As soon as the stay is going to go into effect as soon as the association is informed of the bankruptcy and then makes efforts to stop the collection efforts or stop the limitations on amenity restriction, then there's no problem there. If there's access to the pool is denied or a key fob card has been deactivated, as long as the association is unaware of the case, then there's going to be no repercussion. But as soon as we find out about it, we want to make those changes right off the bat.
Okay. And is there any one slight question back on the foreclosure, but can the association suspend utilities if they have that right? Not utilities, I'm sorry, amenity use, if they have that right going through the foreclosure process?
Absolutely.
Yep.
Okay. All right. And if what happens if an owner is in active collections and they then they and or they file for bankruptcy? Obviously it won't be active because you'll have stayed it, and then their home is burned down. This sounds like a specific question, so I think you need to call Vicky or Craig. But if there's a loss of the property, so that again seems very specific. But anyway,
I can give a general answer on that. So, well, it's going to depend on what chapter they file. The question here is what happens with the insurance proceeds, and who's going to be liable for the assessments going forward. This is a very factual, specific question. So, yeah, if this is a situation that your association, your neighborhood is facing, please contact me about it. But this is handled in a certain way, but it does focus on the replacement or insurance proceeds and how those might play into the bankruptcy estate.
Okay. And now you're going to talk about pre and post petition, right? So there are a couple of questions. Like there's a very specific individual question, so we can't take specific questions, but you're going to talk about the obligation to pay assessments once you file for bankruptcy.
That's right. So when there's the bankruptcy filing is the best way to think of this for the purposes of the stay and essentially the account and accounting afterwards, is that it's a line in the sand as the date that the petition was filed. So everything that was incurred in terms of their account, charges, payments, their account prior to the case filing will need to be separated out. And the ledger will need to be split into a pre-petition account and a post-petition account. In either I mentioned chapter 7 and 13 because that's what we see most commonly. We're going to touch on 11 a little bit later, but whether it's a 7 or a 13 or an 11, in any of those situations, all the assessments that come due after the case is filed will be the responsibility of the debtor owner to pay directly to the association or us if we have an active file for that owner directly to us, and it will not be a part of the case with some limited exceptions.
And so on the pre and post petition, what about, so you're splitting the ledgers. What about the sending out the invoice? Is there any for the post petition amounts? Is there anything to note on that?
That's a great question. And sometimes this is easier said than done, but we would prefer that the communications be limited to only post petition amounts that come due. And this is, invoices, reminder letters to the individual debtor. Anything that has the full account balance listed on the statement should be removed completely. So that might not be the easiest change to depending on the system that you have, but if you're sending a debtor owner mail about anything owed post bankruptcy petition, please just remove the full amount owed from that letter.
Yeah, and if they can't change the letter, it'd probably be better not to send anything, right?
Yeah, I would prefer that nothing be sent because we do see some issues with this. Technically, it's minor and not litigated much, but that's technically a stay violation. It also is likely going to differ from the amount that's actually owed based on the trustee's accounting. But I would stay off. I would just refrain from sending any letters if you're unable to remove that full account balance on the letters that are sent post petition.
Great. Next slide, please, Jocelyn. So let's move into some specifics about the types of bankruptcy, because you mentioned 7s and you mentioned 13s and 11s. So what do we deal with the most, or what do we see the most?
So the most common, Chapter 7 and Chapter 13 by far. I'll start with Chapter 7 first, even though out of the two, this is the least common. Chapter 7 is what people know as a complete bankruptcy. It's called a complete liquidation. The goal here for debtors is to discharge their debt. So to walk away with a fresh start and basically rid themselves of any unsecured debt that they had prior to the case. In these cases, there's a third party that's involved called a Chapter 7 trustee. They will review the debtor's income and expenses and assets and exemptions that they claim to determine whether any of their property can be liquidated and sold, and then to raise proceeds to pay into the bankruptcy estate or to their creditors. Most of these cases will not result in a payment to creditors. So the association typically does not receive money in a Chapter 7 case.
So wait, are the creditors just out of luck in a 7? There has to be some rules. Otherwise, I don't know why we're all working so hard to pay our own bills.
All right. So yeah, absolutely. It's not that easy to file Chapter 7. First, there's an income rule. In order to qualify for a Chapter 7, the court will compare the debtor's income from the prior 6 months to the median income for a household of the same size in the state of Georgia. There are many exceptions to this, but generally, if they're under the median income, you're going to qualify for a Chapter 7. If you're over the median income, there's a complicated test that you have to run to determine whether you do qualify for a discharge. But generally speaking, this is for under the median income households. And the point being, I guess, is that there has to be some hardship in order for individuals to be able to just walk away from their debts. And in those cases, if there is any property that would be liquidated. Just
Got it.
generally,
So
okay.
if a homeowner files a Chapter 7 bankruptcy, should the association just give up and write off the amounts? Why would we even tell them to call us if they're not going to get paid?
Right. So that's a good question. As a general matter, Chapter 7's associates are unlikely to get paid, but there's events that can happen that will give us a chance for recovery. Most importantly, when the Chapter 7 trustee does find assets, we will get notice of when that happens. I think potentially more importantly than that is that we'll have notice of when the case ends. So we are aware when the automatic stay takes place, and if it ends successfully, when the discharge injunction will come into effect, which will be the two ways that the association could kind of trip up by trying to collect on that debt. Um, Additionally, while we mentioned they usually don't have assets to liquidate and pay off creditors, there's some situations where there are assets, or um, where the trustee will set a deadline for us to file a claim. So in order to get paid in the case, we have to file a claim on behalf of the association, which will spell out how much is owed, why it's owed, and in order for any trustee to pay proceeds from the bankruptcy case to the association. Um, in these cases, where liquidation does occur, and this is especially true for associations, is that it's the real property that the trustee finds has equity in it. So this is the home that they will liquidate if it's worth it to the estate. Um, they'll use the proceeds to pay the first mortgage, the association, and the debtor for any exemptions that they've claimed. So in these situations, in most cases, we see the association gets paid in full.
Well, that's great. What you said real property or the home is the most common type of property. What other properties can a trustee liquidate?
So in most cases, what we see is there's property that is either disclosed by the debtor or not disclosed by the debtor that the trustee finds. In these cases, it's very common to see personal injury proceeds or proceeds from a lawsuit that have to be paid to the Chapter 13 trustee. And in those cases, it's important for the association to have that claim in place so that when they are paid to when those proceeds are paid into the trustee, the association will get a cut of that. Um, and essentially, any asset that is not subject to exemptions or that haven't been claimed exempt, that are liquidated, any funds coming in the case can pay off the trustee or the association's claim.
So what if you're the homeowner and you don't want to lose your home, what can you do?
Yeah. So if you file Chapter 7, or if you're looking at a bankruptcy case, otherwise, the Chapter 7 can be converted to a Chapter 13, so that they can pay back the value of their assets over time. And this is uh, uh, worth monitoring in the Chapter 7 case. Another reason we should be involved in those cases, because if it does convert to a Chapter 13, then we don't want to miss the deadline to file a claim in that case as well. So that's very common.
Right, that might be the association's only chance, right?
That's right. And next slide, please.
Cool. So you've mentioned Chapter 13s several times now. Let's focus more on those. What is a Chapter 13 bankruptcy?
Yeah, Chapter 13 bankruptcy is the most common type we're going to see across the board. The Northern District of Georgia has one of the highest percentage per capita of Chapter 13 filings in the nation. So it's a very important topic here. And this is where a debtor will create a plan to pay back all their creditors over a 3 to 5 year time period. Um, this is only available to individuals and only as opposed to corporate entities, and is only available to individuals with a steady income that they can prove. Um, it's pretty common, especially in the Atlanta area and surrounding areas, for 13s to be filed for individuals who are wanting to keep a car or a house. So in most cases, the house is going to be heavily involved in the case, and a big reason they're filed in the first place. And Chapter 13 cases can actually be good for secured creditors. The association has a lien on the property, so that's going to put us in a good position in the case. So anything that was owed prior to the case filing must be paid in the Chapter 13 case. This may take place over 3 to 5 years, which is obviously longer than the association would like, and longer than most payment plans you would agree to with the owner. But the association must be paid, and if they want to keep the house, and they must be paid back with the interest according to the declaration. So It's not it compared to a 7 or in some other situations, this is 13 is not the end of the world.
Yeah,
If it's successful.
yeah, that's huge. I used to do in a prior life collections for credit card companies, and honestly, they just closed their file whenever bankruptcy was filed. They didn't even monitor long enough to see if the bankruptcy was discharged.
Right. So so let's talk a little bit more about if we could change the next slide, please. A little bit more about the Chapter 13 plan, because this is where most of the action goes on. Um,
Sounds good.
so the owner has to submit a payment plan to pay back their debts. Again, we look at the interest rate, monthly payments, or any special provisions that are required in the plan to determine what's going on and what we oppose in the plan.
What happens if the association doesn't like what the debtor proposed?
So it depends on some of the errors that the debtor might have filed in the plan. We commonly object if the interest rate is lower than the declaration provides for, if the plan proposes to pay an amount that's lower than the actual debt that's owed, and most importantly, that the debtor has failed to pay post-bankruptcy petition payments, assessment
Okay.
payments. So next slide, please. So in the slide, we have a just kind of a sample plan, what it looks like, and how it would be treated, how the association's claim would be treated in the plan. And so I mentioned earlier, splitting the counts into pre and post petition bankruptcy filing, and this is where it's most important. So the Chapter 13 bankruptcy will handle the pre-petition assessments that existed, but not the post-petition assessments. So those need to be paid directly. When what we do in the case essentially is we file a notice of appearance, we'll file the claim, submit the proof of claim, and then if the terms of the plan here are not as we would like them to be, we will file an objection to the confirmation of the plan.
Got it. So what does it mean for a Chapter 13 plan to be confirmed? Is that when the case is over?
No, not exactly. The confirmation is essentially the judge's stamp of approval on the plan, and it becomes effective and its terms are binding on the creditors. This takes place somewhere between 90 days and a year after the case is filed. Some cases it could take longer than that, but it doesn't mean that the case is over until the payment plan is paid in full.
Got it. So what happens after the confirmation? And next slide, please.
So once the plan is confirmed, its terms are binding. Essentially the debtor will maintain payments on the case, and it just kind of hums along until either the payments are made or not made. And if they're for some reason not submitting documents to trustee, or some other things that might trip them up, the case would just move along based on their payments. The biggest issue we see post confirmation is that the debtor fails to maintain ongoing assessments. There's a couple different remedies for that, depending on the size of your association, the frequency of your assessments, and the amount of the assessments themselves. I would have different suggestions. Generally, what we do is reach out to the debtor's counsel to see if they could get this caught up. And if for some reason they're not able to do that, we could file a motion for a leave of stay with the court, which basically results in one of two things. One, any post bankruptcy assessments will be modified to add into the plan to be paid back through the case over time, or two, our motion could be granted. And what that does essentially is set the stay aside or that protection in place so that we can pursue collection efforts outside of the bankruptcy case. That has its pros and cons. If that's granted, then the Chapter 13 trustee will stop funding the claim, so they'll no longer make payments on the pre-petition debt. If you're situated with a foreclosure order or a judgment already in place prior to the bankruptcy, this may be a good option. If there's not a judgment we could collect on, and we'd had to pursue the entire collections process from beginning to end, it may not be the best move considering that the trustee has to make payments on the debt anyway. So it's kind of a case by case situation. Those are the two biggest, that's the biggest issue you see post petition. So if we could change slide, please. So let's look at just briefly wanted to touch on Chapter 11's.
Yeah, what is a Chapter 11? I had never heard of these until a couple years ago.
Yeah, so these are definitely becoming more common amongst associations. A Chapter 7 is a type of bankruptcy that's designed for corporate entities, although individuals can file a Chapter 11 and it's typically limited to very high income individuals. We have seen an increase in investors, increase in Chapter 11s as investors continue to purchase properties in your associations. And just kind of briefly wanted to touch on a couple of points here, because although somewhat rare, we are seeing more of these, and they can be very time consuming and can hold up the property for a while. So Chapter 11s can be in the liquidation or reorganization form. So it could either be the debtor can propose to sell the property or pay back their assessments over time. Some of the reasons that an individual or a company would file these would be that it affords them a lot of flexibility. So there's not a third party trustee that works for the government that's overlooking the case. It gives companies a long time to propose a payment plan back, as opposed to a very set time period like a 13.
Got it. So are there different types of Chapter 11s?
Yeah, so there's several different types. Chapter 11 law can be very complex. I wanted to touch on one real briefly because we're starting to see a rather high uptick in these. There's a classification or designation you can make when filing a Chapter 11 petition, and that's the one we see more frequently now is that of a single asset real estate Chapter 11 or SAR. These are designed originally for commercial creditors who own one piece of commercial property, but we're starting to see more come out of associations with one piece of property that is the property in your neighborhood, and they're using these cases to essentially stall foreclosure until they can find the highest bidder on the property, so they could do an individual sale. So these tend to drag out for a while. Just something to kind of be aware of, especially if you have businesses that are owning property in your community, and it might be something that you run across one day.
Yeah, so what should the association do if a Chapter 11 is filed in their community?
Yeah, just call us and I'll take a look at it and we'll review it and advise from there. Wanted to touch on something real quick, just to make this distinction. That's how a bankruptcy case can end. Basically, there's if we could change the
Next
next
slide, please, Jocelyn.
So there's a dismissal and there's a discharge. Dismissal means the bankruptcy case failed; it was not successful. This puts us back at square one. We want to undo the ledger split post petition and basically operate as though the bankruptcy case never happened.
So how is that different from a discharge then?
A discharge is where the court ordains the debt no longer valid. So that means that the case was successful. The owner no longer owes the debt. It also puts something called a discharge injunction into place, which prohibits creditors, the association, from collecting on that debt that was discharged in the bankruptcy case. And the repercussions for discharge violation, discharge injunction violation are the same as an automatic stay. So something that we want to keep a pretty close eye on and make sure our records are accurate as soon as the case is either dismissed or discharged.
And so what happens to the debt itself? It's basically gone as far as our clients are concerned.
That's right. The debt we essentially needs to be written off completely from the books, and we want to make sure that there's no communication with the individual trying to collect on that debt going forward. And we could go to the next slide, please.
Well, Thanks, Craig. That was a lot of really great information on bankruptcy. So the third section of our class is on collecting fines, and I am going to see what I can get through in the 5 minutes we have left.
You had a lot of
Um,
questions and we got through all of them but two. So you go forward and then I'll ask these last two questions at the end.
okay. So I'm gonna skip the poll, and Jocelyn, if you could go to the next slide. Um, so, here I have a list of background considerations that we came up with, which is, like things that questions association should be able to answer if they want to fine or collect fines from their homeowners. And keep in mind that this doesn't come out of nowhere. Most homeowners buy into these communities because they like what they see. They like the neighborhood, they like how it looks, they like the association for maintaining their property values, they like the pool, they like the tennis court, all of those things that associations provide. And it's also not just maintenance or appearance issues. You know, Homeowners also generally don't like leasing in their communities, or at least there are communities of associations who don't want leasing in their neighborhood. Or they want it under certain circumstances, like having a cap or certain terms and things like that. And the fines come because no one really likes to see someone else get away with breaking the rules. When you bought in the neighborhood, everybody agreed to a set of rules, and it just really irks neighbors when people aren't following the rules. So the first question that I think is important for a board to look at is, what are the association's enforcement rights? Fining is not usually your only option. But there could be self-help, there could be towing, there could be eviction, there could also be filing suit for injunctive relief. And it fining can be the easiest option, but I think it's really important for boards to know that it's not the only option. The next question after that is this something the association can enforce? Because rights are specific to your association and your governing docs. So not everybody can govern leasing. Not everybody can govern landscaping and things like that. We're also going to look at whether or not your association has set forth a specific fining procedure. And if it does, do you have a template that complies with that fining procedure? If not, we will be more than happy to work with you to have one. And then finally, the last two questions sort of go to more practical considerations. Do you have proof? As attorneys, we love pictures, but pictures aren't the only kind of proof. We could have witnesses, we could have dated witness statements, things like that. And the last question, which I think is particularly important and often very overlooked, is what is the plan if fining does not get the owner to cure the violation? We can't just stop there. We've got to look at what is our next steps. So if we can move to the next slide, please, Jocelyn. And so what I have here is a very simplistic version of how I think the association handles the procedure in-house. So first, obviously, we have to find out about the violation. However, you get that either from a monthly drive-through, or neighbors are reporting things that they see, or you record it, things like that. Most of our clients are not looking to fine the first time they see a problem, although it does depend on the violation itself. If you've painted your house lime green without permission, there's really no saving you. But most associations like to give warning, especially if it's landscaping, or trees or anything like that. Even if it's something that is not pictures, obviously we love pictures. But even if you don't have pictures, there's other kinds of proof. If we're talking about leasing specifically, a picture might not be helpful. In which case, documentation from a neighbor about who's coming and going and when, or Ring doorbell camera footage, all of that also counts as evidence. And outside of the evidence, you also need to get in touch with the owner. And most associations, like I said, like to give warnings. And even if your process doesn't mandate it, we love courtesy notices. Give them as much notice as you want and give them as many chances as you want. But when we get to the final warning of fines, this is where we need to strictly comply with the association's governing documents. Going back to the association specific fine procedures, if it requires 2 letters, send 2 letters. This is also usually a good point to be like, okay, do we have evidence? If not, this is a great time to go out, take more pictures, talk to the neighbors, things like that. And then at the bottom, you'll see what I have put out as a recommended timetable of how quickly you have to act. And I think it's much faster than we've all been used to lately. But we really recommend doing nothing but fining for only about up to 60 days. And then we really encourage the board to look at other options. Not that we're going to stop fining, but that there should be additional action, either filing suit, self-help, towing if it's dealing with a car, you know. And so that's something that our attorneys can help each association work through because it is a very association specific analysis. Um, I am going to end my class there because we are out of time. There are some additional slides, and I'll be happy to answer
Yes.
specific questions about fines via email.
And then, so I'll wrap it up with these last 2 questions. Can you all let folks know, you talked about the finding and how long you think you should fine. Give the big picture on the process for collection generally. So you have the lien or a notice of lien, the lawsuit, and
Yeah,
then
so it's going to follow the same procedure as our typical collections file. We're going to start with a demand letter. It's just going to also include the fines, and we're going to record a lien or notice of statutory lien. After 40 to 70 days, depending on the type of association and what remedies we're pursuing, we're going to file suit. And that is going to be an all-encompassing lawsuit. It's going to collect any unpaid assessments. It's going to collect any unpaid fines. If the violation is still going, it's also going to pursue injunctive relief to compel the owner to cure the violation. We're basically going to bring all of our issues in one lawsuit against the owner and resolve them all.
all right. And then the last question is back to our beloved SB 46 Act 715. It is not beloved, but there's a question about non-registered associations and can they still collect from delinquent owners before the December 31st, 2027 deadline? So first, if you're not registering, associations can't collect fines and fees. So non-registered associations can't collect fines and fees. Vicki and I both were on a new Secretary of State working group that started as of last Thursday, and we'll be meeting every 2 weeks. So we're actively engaged with the Secretary of State because there's more meat that needs to be added to the bones of this act. And that's the Secretary of State's job, is to add more clarity on a lot of these undefined terms in the act. So we're working with the Secretary of State, offering our advice, and hopefully we will have clarity on some of these vague provisions. So look for more details on that. In the meantime, as I mentioned, we will be sending out the next reminder of this act, as if you didn't know already, will be our checklist. And then as we know more from the Secretary of State, we'll of course be publishing that. We don't expect them to make any decisions until December. So thank you again for joining us. We've come to the end of our time. We are nearing 100 reviews. We have 4 to go. You may have heard me before say we are in celebration of our 10th anniversary this year, looking to get those 100 reviews. from our clients and not from the people we are suing on your behalf because they don't always love us. But we're out there working for you and fighting the good fight, doing whatever we can to help you. Thank you for joining us, taking time out of your day. Please let us know if we can help with any specific need that you may have. And until next month, look for Jocelyn will be sending out the registration for our August class soon. And we look forward to seeing you then. And let us know if we can help you in the meantime. Have a great afternoon.